Michael Proctor.
Resolving cases resolves uncertainty.
The individuals in the House diverted attention away from themselves towards Ms. Reed.
It should never come into our case.
With the procedural things that might be asked for.
Brian Elbert, Nicole Elbert, Matthew McCabe, Jennifer McCabe, and Brian Higgins.
Has Karen Reed been sandbagged by the removal of her case against Michael Proctor at all out of the state court into the federal court?
You lost. And you know what you did.
The procedural tie-ups in the ongoing Karen Reed matter just continue. In this episode, we look at the removal of a state case brought by her into the federal court. I'm attorney Andrew Myers. This is About the Law. Joining me is California attorney Yolie Medina. Hi, Yoli. How are you?
I'm fine. How are you?
I'm good. Now, did this surprise you at all that the case that Karen Reed brought against a whole bunch of defendants, including Michael Proctor and others, was just, without any notice to us in advance anyhow, removed to the federal court? Was it a surprise?
Not so much surprised, but I didn't think they would do this, but I knew that it was a possibility because of the federal questions, the civil rights claims. That there might be a possibility that they would do it, but I didn't think they would do it.
So let's just clarify things to our viewers. Our viewers, by reading the comments, are really smart, but let's just make sure that we have clarified for them what's going on here. After the criminal trial, there was focus on a case that had already been brought by Paul O'Keefe on behalf of the estate of Paul O'Keefe against Karen Reed and the two bars where she and John O'Keefe were served the night before John O'Keefe's death. Okay, so that's case number one. Then case number two was brought by Karen against Michael Proctor and a bunch of other defendants. We'll go over them in a minute. And that was brought in a different county down in Bristol County. And the idea was, because a lot of the facts were connected, they were going to connect the two cases in a motion for consolidation. But that apparently has been, sandbagged or circumvented by the removal by Proctor and all the others of Karen's case to the federal court. I hope everybody followed that.
Right. So, if they had consolidated it with the case that the O'Keefes have against Karen Reed, if they had consolidated it or brought those defendants in the case, in the O'Keefe's case, it would have been harder to remove because the bars that are defendants would have to consent to that removal, and they most likely wouldn't. So I think, by filing a separate action, they ran the risk of having the case removed.
So I wonder if this is a strategical fail on the part of the Karen Reed attorneys. They didn't want to go into the original case, the wrongful death case by the O'Keefes. They didn't want to bring all of their claims into that initially because the judge was kind of cool to that when they mentioned that during a hearing a couple of months ago. So they brought this separate action in a separate court in a separate county with the intention of consolidating them all. Now that's not going to work out. It's a fairly simple, although it sounds complicated, it's a fairly simple procedure, I guess. I don't know. But here is the paperwork that was filed. And by the way, this case in Bristol County has been closed. If you go onto the docket, it says, the case is no longer alive there. So
once they file a notice of removal, and there's a checkbox, if you go to the end of the document, there's like a civil case cover sheet or something.
I'll show you. Yeah, I looked at it, but let's show our viewers. Hang on. There it is. Okay. Yeah.
Go up a little. Okay, so it says basis for jurisdiction, and you see it checks off federal question.
Right.
Okay. So,
Right.
so that once the clerk sees that, it's automatically a case. It gets removed. Now it's up to the opposing party, who would be Karen Reed's attorneys, and
Right.
she would have to file a notice of remand and give her reasons why it shouldn't be in federal court. And that may happen, but I don't know. But it is simple. And I've had these types of cases, like I said, against Lowe's and, other nursing homes that had conglomerates, and, they were based, their headquarters were in Georgia. And I was able to get them remanded back because they tried to do it on diversity jurisdiction, which is number 4. And that means that the parties are in separate states.
Right. So before we dig into that, why don't we just read the documents, because they're pretty self-explanatory. They often aren't, but notice of filing, and this was filed in the Superior Court in Bristol County, Massachusetts. Please take notice that Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins have on this date filed a notice of removal in the United States District Court for the District of Massachusetts, pursuant to 28 U.S.C. 1446 et sec. A copy of the notice of removal and all accompanying documents is attached here too at Exhibit A. So that's the procedural federal code that allows for things to be removed to the federal court under the proper circumstances. And the proper circumstances, as you just pointed out, are generally there are 2 ways to get federal court. The federal courts are very, very picky about jurisdiction. And one way is, as you pointed out, diversity jurisdiction. All of the defendants and all of the plaintiffs have to have diversity of citizenship. What that means is that they have to be in different states. The other potential way to get jurisdiction in the federal court is federal question, whether it's a federal statute, which we'll talk about in a minute, that needs to be adjudicated by the federal court. So here we go. It's only about 5 pages. Do you want me to take the odd ones and you can take the even ones? Okay. So notice
And
of removal.
if there's a footnote, you can read the footnote to the paragraph.
Okay. All right. Notice of removal. Defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, collectively removing defendants, hereby remove this case from Bristol County Superior Court, the Superior Court, to the United States District Court for the District of Massachusetts, pursuant to those statutes, and as grounds for their removal state as follows. So, yeah, I always say the footnotes are very important. A lot of people don't read them, but they're important, especially here. In filing this notice of removal, removing defendants preserve all defendants and objections, including those pursuant to Federal Rule of Civil Procedure 12B, C, and then they cite a couple of cases. When a defendant removes an action from a state court in which he has been sued, he consents to nothing and waives nothing. He is exercising a privilege unconditionally conferred by statute, and since the district court to which he must remove it is fixed by law, he has no choice, without which there can be no waiver. So what all of that means is they're saying we're not waiving the right to bring in later claims, and one of those later claims would be against the Massachusetts State Police and the town of Canton. They can't be brought in now because they have to go through a procedure that we talked about in a previous episode known as presentment. You can't just sue a government entity without going through a procedure under Mass General Laws, Chapter 258, the Tort Claims Act. So then they put a statement of the case.
Okay. And number 1, on or about November 17, 2025, plaintiff Karen Reed, plaintiff, filed the above captioned action in the Superior Court, the state court action. The complaint purports to assert 7 causes of action: 42 U.S.C. 1983, malicious prosecution under the 4th Amendment, count 1. Another claim for 1983, supervisor liability, count 2. Another claim under U.S.C. 1983, conspiracy to deprive Ms. Reed of her 4th Amendment rights, count 3. Massachusetts Civil Rights Act, count 4. common law malicious prosecution, count 5, intentional infliction of emotional distress, count 6, and civil conspiracy, count 7, with counts 3, 4, 5, 6, and 7 being asserted against the removing defendants. A true and correct copy of the complaint, civil action cover sheet, civil tracking order, acceptance of service on behalf of Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins are attached here too as Exhibit A. And then there's a footnote.
Uh-oh.
It says, no proceedings have occurred or been scheduled in the state court action. Accordingly, Exhibit A constitutes all process, pleadings, and orders that have been served on removing defendants or retrieved from the Superior Court's docket prior to filing this notice. Okay.
So what that means is that the federal court requires, they're not going to be blind. They require the removing party, require the defendants in this case to get all of those documents in the other case and get them over to the federal court right away. And so that shouldn't be too hard these days with PDFs and the requirement of electronic filing. I guess in the old days, you would have to run to the photocopier and copy, potentially reams of paper, but we don't do that anymore. So paragraph 2 of this notice of removal. By way of background, the Superior Court action arises from plaintiff's ongoing and malicious attempt to listen to this language, listen to this rhetoric. Plaintiff's ongoing and malicious attempt to evade responsibility for the death of John O'Keefe by smearing and defaming witnesses who participated in the prosecution of her. The case is a vengeful abuse of the judicial process, and removing defendants will make arguments in that regard at the appropriate time. I don't know about you, and correct me if I'm wrong. That language is somewhat inflammatory, and I would do a motion to strike. And just
I would do a motion to strike as well in terms of malicious attempt to evade responsibility for the death of John O'Keefe, because she's not evading anything. She was found not guilty.
Exactly. In two courts, in two trials. Admittedly, a lot of people say, the first one didn't count. The first one did count. So I think this is inflammatory opinion evidence. A complaint is supposed to be, and we've gotten away from it, it's supposed to be a short, concise statement of the facts to put the opposing party on notice as to what the case is all about. And this, that's just inflammatory in my view.
Number 3. Counsel for removing defendants accepted service of process on removing defendants' behalf on November 25th, 2025. Therefore, removing defendants are timely filing this notice of removal within the 30-day time period from the date of service set forth in 28 U.S.C. section 1446B. Then it says it has a case, and then it says 30-day removal period runs from the service of summons and complaint. And then there's a footnote, number 3. It says removing defendants have not yet filed an answer or otherwise responded to the complaint, but will file such an answer and or response absent an extension within 21 days of service in accordance with federal rules. In accordance with the federal rules. As noted, removing defendants accepted service of process on November 25th, 2025. Yeah, you said that already.
So, interesting question that I have, and tell me if I'm making too much of it. It's an abusive litigators, and there's another term, I just can't say it. It's an abusive litigators tactic to do these things when there are short deadlines right before a holiday. And this was filed right before Thanksgiving. Now, yes, I understand, as you explained earlier, these removals must be made within 30 days. But, having been done in just days before Thanksgiving, that truncates that 30-day period, because all those days are, if it's more than 10 days under the federal rules, they count. If it's less than 10 days, you can, skip over the holidays. This is a B litigator's tactic to do these things where holidays, especially a holiday like this, where Thanksgiving's Thursday, nobody works Friday. Then there's the 2-day weekend. And by the way, nobody works on the Wednesday before Thanksgiving either. So they've lost 5 days, and it's really down to 25 days.
And if the plaintiff, meaning Karen Reed, if she wanted to file a motion for remand, I don't know what the time period is at the moment.
I thought it was 30 days, isn't it?
A motion for remand?
That's what I thought.
It might be. I just didn't look that up. But if they wanted to file a motion for remand, they're kind of stuck in the holiday period.
That's what I'm saying. Yeah, that's what I'm
Yeah,
saying. And
yeah.
okay, so paragraph 4, all named defendants who have been served consent to and join in this removal in accordance with the federal law. Defendant Brian Tully's acceptance of service was documented in the Superior Court on November 24th, and that's Monday of Thanksgiving week. And counsel for defendant Tully has confirmed that he assents to this removal. While no acceptance of service has yet been filed with respect to defendant Sergeant Yuri Buchanan, Sergeant Buchanan's counsel has informed undersigned counsel that he consents to the removal. Now, the federal courts are really sticklers for enforcement of the rules more so than the state courts, in my experience. So I'm wondering if that little loophole is something that Reed can point out, or would that be too picayune of a complaint? I don't know.
Well, you know, I would think that there would be some declaration of consent, but I don't. You know, this isn't a complaint. This is just a notice of removal. So,
Right.
I mean, maybe the federal court will say, well, you don't have any. I mean, this is just your word, and it's not under the penalty of perjury. But it might be in the declaration. Well, no, it's not.
Well, the thing is that, you know, the court could always order them to, you know, file something with somebody's signature on it, and then under Rule 11 they've got. So I guess it's a minor issue. Upon information and belief, defendant Michael Proctor has not yet been served, but his counsel has advised undersigned counsel that defendant Proctor consents to removal as well. A civil action removed pursuant to Section 1441A requires the consent of all defendants who have been served. And then they cite, you know, the law that requires that. Oh, you got a short one.
Number 5, venue is proper in this court pursuant to 28 USC 1441 and 1446A because the United States District Court for the District of Massachusetts is the federal district in which the Superior Court is located and where the state court action was originally filed.
Would we bore our viewers now to say, you know, the federal courts are very strict about adhering to their rules, and there are two different things that the federal courts are really concerned about, and one of them is jurisdiction, and that breaks down into personal and subject matter. That's jurisdiction. That's whether the court has the legal ability to adjudicate the matter. Then there's venue. Is this the right place? Think of you know, a rock concert or any concert. Where's the venue? Philly, New York, LA. So that's what that's all about. You've got to have both. And you've got to state it in the complaint. Not so much in the state courts, but the federal courts want you to spell it out for them. They're not going to do your homework for you. Number 6, as required by 28 USC 1446D, removing defendants will promptly serve written notice of the filing of this notice of removal and the removal of the state court action on counsel for plaintiff as evidenced by the attached certificate of service, and will promptly file the same with the clerk of the Superior Court. Okay.
Number 7, pursuant to 28 USC 1446A and LRD Mass 81.1, within 28 days of the filing of this notice of removal, removing defendants shall file certified copies of all records and proceedings in the Superior Court, as well as a certified copy of the docket and all docket entries.
That's what I was talking about before. I believe that can all be done electronically now. 8, the removal of this action terminates all potential proceedings in the Superior Court. Footnote 4, removing defendants have good faith and sufficient defenses to this action and do not waive any defenses, jurisdictional or otherwise, by the filing of this notice. Removing defendants intend no admission of fact, law, or liability by this notice and expressly reserve all defenses or motions. So what they're saying here is this is a procedural thing, guys. We're not waiving any claims, counterclaims, defenses. Any substantive matter is unaffected by this. This is just a procedural thing, and nothing is to be read into this substantively.
Number 9, this is a civil action over which the court has original jurisdiction under 28 USC Section 1331, and is one that may be removed to this court under 28 U.S.C. Section 1441A because, as set forth more fully below, plaintiff's federal civil rights claim against removing defendants, namely Count 3, Section 1983, conspiracy to deprive Ms. Reed of her Fourth Amendment rights against Proctor, Buchanan, Tolley, the Alberts, McCabe's, and Higgins, is exclusively and expressly based upon a federal statute, and therefore raises substantial federal issues central to establishing plaintiff's claim for relief. And then there's a footnote 5. It says, counts 1 and 2 of the complaint assert separate 1983 claims against defendants Proctor, Buchanan, and Tolley. Okay. So
this could go ahead.
So basically they're saying that there is at least one claim against the removing defendants that confers, federal jurisdiction under federal question. And then there's a other count 1 and 2 for the others.
Yeah. And that brings to mind some real procedural nightmares that might be down the road here. I mean, the courts, as we see here, the federal court, obviously they can adjudicate the federal questions, but now bringing in the state questions, they can do it. They have jurisdiction, but it can bring in some procedural issues down the road. But before we get to that, in particular, plaintiff alleges in count 3 of the complaint that the removing defendants violated her federal civil rights by purportedly acting in concert to deprive her of her Fourth Amendment rights under the United States Constitution, where a complaint invokes 42 U.S.C. 1983. Federal question jurisdiction exists, and there's really no question about that. They cite some law. Almost by definition, a claim under 1983 arises under federal law and will support federal question jurisdiction so long as it does not clearly appear to be immaterial and made solely for the purpose of obtaining jurisdiction. Again, they cite some more law. This is pretty much black letter law. I can't think of an argument against that. Can you?
Well, I mean, not really, but if there is a motion to remand, they might say that they're just doing this. There are more state claims. Well, they'll try to argue the state claims are more relevant than the federal.
Sure.
But they might argue a bunch of things if they file a motion for remand, but maybe they won't.
Yeah, no, what I was saying, and we didn't discuss this before this, what I was saying is that it's pretty much black letter law that application of 1983 is a federal question. I mean, right. It's true that a state court can adjudicate it, but I'm just saying that's black letter law, seriously. Your turn. Okay,
in addition, this court has jurisdiction over the remaining counts in the complaint by way of supplemental jurisdiction under 28 U.S.C. Section 1367A, which provides, in relevant part, in any civil action of which the district courts have original jurisdiction, the district courts shall have supplemental jurisdiction over all other claims that are so related to claims in the action within such original jurisdiction that they form part of the same case or controversy.
Do you know what that makes me think of? Yes, of course, the federal courts can apply state law to a set of facts, and they can adjudicate state issues. However, if a question arises during that application of state law to the facts, and if it's a case that if it's a law that has not been applied fairly clearly in the past, the district courts often will remand just that question, just that one isolated question. They'll remand that down to the state, and in Massachusetts, that would be the Supreme Judicial Court, to adjudicate that one issue. And then the state reports that back up to the federal court. And we have seen how appeals have gone in all different directions in the Karen Reed criminal complaint. So I'm not saying that this should, complicate matters even more, but it's out there.
It could, yeah.
Number 12, indeed, the First Circuit has explained state and federal claims are part of the same case or controversy for the purposes of Section 1367A if they derive from a common nucleus of operative fact, are such that they would ordinarily be expected to be tried in one judicial proceeding. There's a bunch of law that is cited. Plaintiffs' claims refer to and rest upon the same allegations. And again, they cite the facts in the earlier case.
Accordingly, this court may exercise supplemental jurisdiction over the remaining 4 state law and common law claims, counts 4 through 7 in the complaint.
Wherefore, defendants Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins respectfully request that the state court action be removed to the United States District Court for the District of Massachusetts, and that the court enter such order as may be necessary to accomplish the requested removal. So I was surprised. Maybe you weren't. Maybe you have more foresight than I do, but I saw this and I said, wait a minute, what's going on here? And then I went back to the Massachusetts electronic case docket system, and I looked, and the Bristol County Superior Court had already closed the case. If you go into the electronic docket, it says case disposed. So it's over. It's over already. Now,
Yeah.
You and I went back and forth before. I was kind of surprised. I've done a fair amount of federal practice, but I've never faced this question before. So my question to you was, wait a minute, doesn't there have to be some action by the state courts to, allow this to be removed? Doesn't there have to be some action by the federal court to say, okay, yeah, we'll take the case? And you're saying, no, not at all.
As long as they check off the appropriate box and what the basis is for jurisdiction. And I mean, I just remember that as long as you did that, the court clerk would accept it. I mean, there wasn't a vetting of the complaint to look at it to see if it really was, federal question. Once it's removed, then the plaintiff, then can do whatever they need to do to try to remand it back to the state court. So right now the ball is in the plaintiff's yard, I guess, to be able to file something to get it back to the state court.
So Karen Reed's attorneys I would think, certainly have something to say, because their initial strategy was file this clean and clear. Don't let the Plymouth County court meddle into their whole ball of wax with all of these defendants and all these different claims. File it clearly in the Bristol County, Massachusetts court, and then, like I said before, a motion to consolidate. And my understanding is that the motion to consolidate had been initiated under a crazy rule we have in Massachusetts, Superior Court Rule 9A. You don't really file a motion directly in court in the civil cases in Massachusetts. Way back in the late 1980s, they enacted Rule 9A, which says if I want to file a motion against you, I don't file it with the court. I send it to you and I say, Attorney Medina, you have 10 days to get back to me with your reply, if any. And often it's a common courtesy. You might call me and say, can we extend that another 10 days? I'll say, sure. But in the end, you send me your response to my motion. I am required to now package. They call it a Rule 9A package. I take my motion, your response, a bunch of other paperwork, including a certification that we actually conferred on the matter, et cetera. And then you don't file your motion. I file your motion with my motion as a ball of wax. I hope we're not boring our.
Well, I get it. And you just have a pre-filing process that you guys do.
Yeah, exactly. So my understanding, and I had been told that that process had started, that Karen Reed's attorneys had written the motion to consolidate, and it was out there. They were going to be waiting for the various defendants to get back to them. And the defendants said, oh, no, we're going to remove this. And so the time that was taken to write that motion was wasted time. Anyhow, so now the ball is in their court to determine whether they're going to do a remand. Do you think they'll do a remand?
Well, I mean, I don't know if this is a hard one. I mean, I don't know if I would do a remand, because it's clear that there is federal jurisdiction, and anytime you're asserting a federal question, you run the risk of having it removed. Now, there's also the state claims, the Massachusetts state claims. And, the federal court can rule on those under supplemental jurisdiction. And I didn't know about that process that you said. If there's some issue that's not well settled, the federal court will send it down to the state court for that one issue.
Right. And
Yeah.
it happens. It happens quite frequently that you'll read a decision that the federal or the U.S. District Court has a question about how a certain statute is applied. There may not be any case law explaining it. So now the Supreme Court of Massachusetts, the SJC, has to create some case law, and they answer the question, send it back up. So that's one of the monkey wrenches that can be thrown into the procedure down the road.
Well, the other thing is, I think I tend to be more quiet about what I'm doing. In other words, like I would have never brought up to the judge that very first day when they had this status conference that they were intending on bringing in other defendants into the case, because once you do that, you give notice to the other side about what you're doing, and then they have the ability to plan ahead. Now, I don't know what happened that they didn't go along with that motion to get the other defendants in the case and instead filed a separate case. I don't know what happened, what made them change that, but hopefully it wasn't a trick by the by the defense to say, hey, well, and then they remove it. But
that's an interesting question. The other interesting question I have is that, with regard to the two different cases that we explained in the beginning of this episode, do you remember that Hollywood Squares hearing that they had with all of the attorneys, and they said that they were working on an agreement so that there wouldn't have to be multiple depositions, that they would work together, that even if the cases weren't consolidated, which they weren't at that time, they would consolidate discovery. In other words, the Reed people wouldn't depose Proctor in both cases. They wouldn't depose the Alberts in both cases. There'd be one deposition, and it would apply to both cases. Now that one of the cases is in state court and the other case with the same nexus of facts is in the federal courts, does that hold? Does the federal court say, oh, it's okay, you can depose these people in state court and we'll accept all that here, or vice versa?
I don't know, because the federal court has certain rules about depositions that state courts don't have. Like, for example, in California, there are different rules. Like, for example, a deponent can't be deposed for more than 8 hours. Unless they're a PMK or person most qualified or person most knowledgeable. I'm not citing all the rules right now, but I'd have to look them up because
That's interesting. That's interesting because there's no such rule in Massachusetts. I mean, it has to be a reasonable length of time. And what does that mean?
Yeah, and usually that's what it boils down to. I mean, and I think there was a lot of abuse with depositions dragging on for days and days that, the legislature wanted to make it. But I mean, it's basically reasonable time, which they say is like 8 hours.
Right. But,
go ahead. But I don't know Massachusetts if the rules are different or if they can consolidate discovery for the purposes of taking depositions, and because even the federal courts are different for discovery. You have to exchange your discovery at the outset, everything that you have relevant.
Yeah. Yes, you do. And that is kind of a mess. That is really kind of a mess. Yeah.
So that wait until somebody sends you, in federal court, there's a rule by this date, you have to exchange everything that you have. Yeah. And then if you want more specific stuff, you can send out requests. But the first is you just exchange everything.
Yeah. Automatic discovery. Yeah. That's an interesting question. Why don't we save that one for another episode? Because I think that is an interesting issue, and it could be a monkey wrench in this case. I would like to look at our viewer comments this week. And I believe these are comments having to do with the Karen Reed case. And so I'll read the first one from Kim Babalui. And we all know what that means. If a new DA voted in next year, would that person have any influence on keeping Kearney away from the Reed civil case? Morrissey seems to have a lot of influence, at least where Judge Kearney was concerned, but that might be because everything he does seems to be underhanded. Well, that's our viewer's comment. No, I don't think the district attorney has anything to do with who the judge is. The judges are assigned by the regional administrative justice of each county. So unless there's some monkey business that I don't know about, unless, and I know people have reason to be suspicious of everything in the Reed cases, but I don't know. My answer would be no. Do you agree, or would you defer?
Yeah, I agree. I mean, I don't think that the DA would have any influence.
No, I would hope not.
Yeah. Okay. Discovery ? Isn't that when the Commonwealth hid from the defendants? Isn't that what the Commonwealth hid from the defendants? It's clear the courts didn't and don't want to get involved. I know this is civil, but maybe a few more stricter rules around it would help. Yeah.
Well, again, we're in federal court now. In this case, we're talking about in this episode, and yeah, the federal courts are a bit more adamant about applying the discovery rules. And I'll say this: that inverted video would not have gone in federal court. I feel really safe in saying that. If you didn't disclose it in discovery, you're not getting it in federal court. So that kind of stuff would not happen, in my opinion. It shouldn't have happened in the Karen Reed civil cases. In the Karen Reed criminal cases. But I can't believe that a federal court would allow that kind of monkey business. Number 3 from Judith Simpson. I bet they moved this to federal court so that she has a lot of foresight. I wonder if she has a crystal ball, because these comments just came within the last week. And so obviously Judith sent us this, just days before what she saw came to be. It's like a train wreck already, and we've barely scratched the surface. Just my thoughts. And I've said that in the comments section often. I'll respond to people by saying, yeah, the first trial was like watching a train wreck, and the second one wasn't any better. You just couldn't take your eyes off of it.
Yeah. Good comment.
Yeah. Thank you, Judith.
Okay. Number 2, Chris Shergy, 10:30. I don't get it. You mean the guy who didn't bring any charges on Proctor or anybody else and left everyone in the dark on what that investigation was all about? That guy, that's the guy running for the office?
Well, I don't know. As I pointed out in responding to this in the comments section, Mr. Deitch was a U.S. attorney. He wasn't the FBI. He was a U.S. attorney in the U.S. Attorney's office. It's a big office. He's one attorney, and maybe the fact that he was frustrated by, and this is my speculation and my speculation only, he's more than welcome to come in. We're going to try and get all the candidates, by the way. He may well have something to say about that, and that may well be one of the reasons he left the U.S. Attorney's office. So let's not jump the gun on that one. Let's give him a chance. Okay, comment number 1 from Britt Being Human. Karen is eminently capable of participating in her own defense. He said in an interview that she has a photographic memory and recalled a time where he asked her about a specific statement made by someone, and she immediately said something like, it's in XYZ report, middle of the page number. She knows the details and nuances of this case better than anyone. And this goes to that comment during that Hollywood Squares, meeting with all of the, I think, a dozen attorneys. Alan Jackson was looking at his schedule book, and he said, that's okay for me, but I want to check with my client. And the judge kind of bristled at that and said, oh, well, it doesn't rise to constitutional proportions. As well, it may not in civil court. But, a person that's litigating a case, a primary person, in litigation has a right to be there. Maybe not constitutionally, but I know some of my clients want to be there. Some of them could care less.
If she has intricate knowledge like this commenter is saying, it would make sense for her to be there. She's kind of helping the defense, and he needs her for various things. In case something comes up and she might know about it, and more specifically, like give him a page number or whatever, because the trial attorneys, they don't. I mean, they may not get into the weeds until trial. You know what I mean? And she might know more of the weeds in the case. So
Well, yeah.
I can see why he would want her to be there. It's just not common in civil cases for you to say, "Let me consult my client," when it's like a status conference or something.
Yeah, I guess. But I agree with Britt being human. Not that I agree with Britt being human. I'm sure she is, but I agree with her point here.
Yeah.
So that's it for our comments this week. Good comments. We had some other good comments, which we'll get to in another episode with respect to Howie Carr. People love that episode that we did, the live interview with Howie. That went fairly well. So I guess it's time for us to call on those people in the Karen Reed case to tell people, to please subscribe. It costs you nothing. We aren't trying to sell coffee mugs or aprons or financial advisors. We don't run ads, but it is free to subscribe, and that's all we ask you to do.
Pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
Okay, thank you guys. Yoli, your closing thoughts.
This was just a strange move. Not a strange move, but maybe unexpected for a lot of people. I just wonder if it was unexpected for Karen Reed's counsel, or if they knew it was coming.
I don't know. They say you should always anticipate everything, but I don't know if this was anticipatable. Not that that's a word. My closing thought is, it's just, there are so many intricacies in the procedure that are ahead of us. Will it be remanded? What would be the grounds for remanding? How will they deal with the previous agreement that they'll cooperate in depositions? Will the federal court allow state court rules? Will the state court allow federal court rules? Some kind of ability to relieve that tension and make it easier procedurally. I'm not saying substantively, but with respect to it's just a train wreck. That's all. It's a train wreck. Okay. I have an idea for an emoji, unless you have one.
Train.
A train. A
train.
Locomotive, a train car, anything like that. And all right, Yoli, it's been a crazy couple of weeks for this case, and I guess there's more ahead. Have a good one.
Okay, bye-bye.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.